Welcome to KNL Gates Working Wise podcast series. My name is Hernandez and I am an associate attorney in the Portland, Oregon office of the firm's labor employment and workplace safety practice area. In this podcast, I will discuss some of the different ways employers can protect company trade secrets or other forms of confidential information. I will also go over some of the steps to consider if faced with actual or threatened misappropriation or disclosure of a trade secret or confidential information. Companies can spend years and significant resources developing and sourcing information and methods that, if misappropriated or disclosed, may cause harm to the company and unfairly give another party an economic advantage without having to spend the necessary time and money or resources. It is no secret, then, that such information is valuable and should be protected. So, what is considered confidential information or a trade secret? Generally, confidential information is the more encompassing term that helps define the information a company considers proprietary, sensitive, or otherwise gives it an economic or competitive advantage. There is no specific definition of confidential information because what one company considers confidential may not be so for another. Nonetheless, confidential information generally includes things such as the company's financial information, marketing plans, clients lists, vendor lists, pricing margins, and, of course, trade secrets. Trade secrets, in turn, are addressed in both the Uniform Trade Secrets Act, UTSA, which most states have adopted, and the more recent Defend Trade Secrets Act of 2016, the DTSA. The definitions under both acts are similar and generally define a trade secret to mean all business, scientific, technical, or engineering information, including a formula, a pattern, compilation, program, device, method, or technique or process that derives independent economic value, actual or potential, from not being generally known and not being readily ascertainable using proper means, and that is subject to reasonable efforts to maintain its secrecy. While both acts are similar, there are some differences that should be noted. Here are two main differences. The first difference is where claims may be brought. Claims under the UTSA must be brought in state court if federal jurisdiction is not otherwise met. By contrast, the DTSA provides the parties with direct access to federal courts. Generally, bringing a trade secret claim in federal court is seen as more advantageous because federal courts are often better suited to deal with complex issues such as dealing with the fact-intensive nature of trade secrets and confidential information cases. Secondly, the DTSA provides for a civil seizure mechanism allowing companies to prevent the dissemination of trade secret information by quickly seeking an order of the court to seize the property prior to a formal finding of misappropriation. This mechanism is, however, ordered only in extraordinary circumstances and requires meeting a relatively high threshold showing irreparable harm and likely success at trial. Now, let us assume that your company has confidential information or trade secrets that it wishes to protect. How is that protection accomplished? At the front end, the company needs to consider having policies in place, including in their handbook, that defines what it considers to be confidential information. It should also require an acknowledgement by the employees that they understand their obligations to maintain such information from disclosure, misappropriation, or use that is not in furtherance of the company's business. Separate from the handbook policy, a company should consider having written non-disclosure agreement that clearly provides an explanation of the employee's obligation, restrictions, and protections. For instance, the DTSA provides for enhanced recovery of damages and attorney's fees for the employer. However, to take advantage of those remedies, the employer must provide notice to the employee of whistleblower immunity and any contract or agreement that deals with the use or disclosure of confidential information or trade secrets. Another option is non-solicitation agreements aimed generally at restricting former employees from contacting the employer's clients or vendors for the purpose of directing business away from the employer. Yet another mechanism is the use of non-compete agreements. Employers must use care when using non-compete agreements because states tend to take different approaches on their enforceability. For instance, California broadly bans non-compete agreements as against public policy. Washington, on the other hand, generally allows non-compete agreements so long as they meet a three-pronged analysis related to reasonableness. Oregon uses yet a different approach whereby non-compete agreements are voidable and may not be enforced unless a string of requirements are satisfied, including but not limited to providing notice to the employee of the non-compete agreement 2 weeks prior to starting work, meeting minimum salary thresholds, and restricting the non-compete agreement to no longer than 18 months. Accordingly, an employer is well advised to determine if a non-compete agreement is enforceable in its jurisdiction and whether any prior requirements must first be met. Now, what happens when an employee with access to confidential information leaves and the company knows or believes that its confidential information may be misappropriated? The first step is to act quickly to protect proprietary information, to limit the risk of disclosure, and reduce possible financial loss. Waiting to exercise one's rights can be detrimental because the harm likely to be caused may already be beyond remedy. Also, remedies such as injunctive relief are harder to obtain if a court concludes that a would-be plaintiff sat on its rights. Next, thorough fact-finding is critical to succeeding in litigation. Employers must investigate suspected disclosure or misappropriation of confidential information. This includes performing a search to determine if files containing protected information are missing, have been duplicated, or have been transferred. Software may be used to determine if data from computers, servers have been accessed, transferred, emailed, or downloaded, including to an employee's personal email account. The former employer should also try to discover as much information as possible about the former employee's new employment or business activities, which may involve the use of confidential information. Now, consider sending a demand letter. Prior to starting formal litigation, it may be prudent to send a letter demanding the return of confidential or trade secret information, as well as demanding the non-use or disclosure of such information. A letter may be appropriate in instances where a competitor is unaware that a new hire is subject to non-disclosure, confidential, or non-compete agreements. Using a demand letter may also serve as a way to show a court that the company took measured steps to resolve the matter prior to starting litigation and was not merely sitting on its rights. On the other hand, sending a letter may provide the other party with advance notice and the ability to prepare for litigation. Filing a temporary restraining order, or a TRO. A TRO is a short-duration injunction sought to prevent irreparable harm pending a more complete presentation of the facts in a later filed preliminary injunction. In some instances, the threat of irreparable harm may be of such a nature so as to warrant seeking a temporary restraining order without notice or with only limited notice to the adverse party. The TRO process varies from state to state and between state and federal courts, but it is generally fast-moving and requires a significant upfront investment of time from both the business and its counsel to prepare and file. Generally, an issued TRO lasts no more than 14 days from the time of entry by the court. TROs also often require that a bond be paid by the party seeking the order for payment of damages suffered by any party who is found to have been wrongfully enjoined or restrained. In turn, a preliminary injunction is intended to keep things the way they are until the underlying issue is resolved by a decision of the court. Unlike TROs, preliminary injunction cannot be issued without notice to the adverse party. A party seeking a TRO or a preliminary injunction generally must establish that 1. They are likely to succeed on the merits, 2. They are likely to suffer irreparable harm in the absence of preliminary relief, 3. The balance of equities tip in their favor, and 4. Their preliminary injunction is in the public interest. Finally, a company should take care to protect their confidential information and act quickly when disclosure is known or likely to happen. We hope you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at knlgateshub.com, and you can learn more about our labor, employment, and workplace safety practice in our main website, knlgates.com. Thank you for joining us.